Hello everybody, good afternoon. Before I begin, I should apologize, by the way, because I am recovering from a cold. So if I do collapse into a fit of coughing, please do bear with me. So, as was already mentioned, my name is Christina Angelopoulos. I'm a lecturer in IP here at the University of Cambridge. And what I'd like to talk to you about today is an article that I co-authored a couple of years ago, almost a couple of years ago now, with a colleague from the University of Ghent, now transferred to the University of Melbourne, Steen Smet. The title of that article is the same title that I've given to this presentation, so the title that you can see behind me, Notice and Fair Balance, How to Reach a Compromise Between Fundamental Rights in Intermediary Liability. Now, before I begin, I should note that we did approach writing this article very much with a sort of blue skies mindset, a blue skies spirit. And that's also the reason why I thought of this article for this session in our conference today. That is also the spirit through which I present it here today, and I would ask that you perhaps accept it in that spirit as well, as a sort of thought experiment, as a kind of opportunity for further reflection and a call for thinking outside the box, which is not to say, of course, that any criticism you might have, or any thoughts you might have, any comments you might have, would not be well received. Indeed, those would be entirely the point. So before I begin, it's first worth taking a brief overview of the existing legal context, the existing EU legal framework. Now, I'm not going to spend a lot of time on this because, of course, the existing legal framework has been very well canvassed already today by the excellent presentations that preceded this session. Nevertheless, there are a few points that I did want to highlight for the purposes of this presentation, as they are useful for the points I'm going to make within the context of this presentation. So the EU framework, the question of intermediary liability remains at the moment mostly unharmonized at the European level at the moment, except, of course, with the obvious exception of those provisions that we've been talking about a lot today, the safe harbour provisions of the e-commerce directive. Now, for the purposes of our article, Steen and I focus primarily on Article 14 of the e-commerce directive, and that is to say the hosting safe harbour. And as has already been mentioned, the hosting safe harbour introduces what is often termed as a sort of notice and takedown regime. The e-commerce directive doesn't actually make any reference to notification. Instead, it talks more broadly about a concept of knowledge. Nevertheless, the most obvious way in which an intermediary might receive knowledge of illegal activity that has been posted on its platform would be through notification. And so, obviously, as a result, Article 14 is often discussed as introducing a type of notice and takedown regime. The other thing I'd like to point out with regard to the safe harbours, and this also holds true of Article 14 as well, is that they were intended to function in a horizontal manner. That is to say, they are intended to function as sort of holistic tools that are equally applicable to a diverse array of different legal wrongs, whether we're talking about copyright infringement, whether we're talking about defamation, or whether we're talking about more serious criminal offences, such as, for example, hate speech and the incitement, the incitement to violence, or the distribution of images of child sexual abuse. The reason for this horizontal approach that's generally given is that from a technical perspective, the contribution made by the host service provider, the contribution made by the intermediary is in all cases the same, regardless of the branch of law that is involved. While writing this article, however, Steen and I began considering whether the horizontal approach can continue to be valid in the 21st century. We considered that certainly when the e-commerce directive was first adopted, it might have made sense to approach internet intermediaries as sort of monolithic special case scenarios. However, as the internet era comes of age, we question whether perhaps this idea of internet exceptionalism, and with it also internet intermediary exceptionalism, should be set aside and greater nuance interjected into the intermediary liability debate. What spurred our reflections in this regard on particularly was the case law that has been emerging on intermediary liability out of two of Europe's highest courts, the CJEU based in Luxembourg and the ECHR based in Strasbourg. And what this case law has indicated is that perhaps what is necessary in the area of intermediary liability is a more granular approach. The courts did this by focusing not, of course, on the directives, that wouldn't actually be within the jurisdiction of the ECHR in any case, but on more basic legal principles, on the law of fundamental rights and human rights. So essentially what is important to point out in this regard, and many speakers have mentioned this already, when we're talking about intermediary liability, we're talking about what Stein and I in our article called a triadic relationship. So we don't have a traditional dialectic approach between a claimant and a defendant. Instead, a third party, the intermediary, is interjected between the two, so that we have a triagonal sort of setup between, of course, the intermediary, the injured party, and the internet user. Now, each of these different parties bring different rights, different interests to the table. So the intermediary is generally seen as carrying a freedom to conduct its business. It has a right to the freedom to conduct its business. It might also be seen as having sort of an interest in its own free expression as well. The injured party might allege that there has been a violation of its property rights, in particular its intellectual property rights, such as copyright. It might also suggest that there has been some sort of violation of its right to a reputation, or some sort of ill against it on the basis of the principle of non-discrimination. And finally, the end user also has rights that have to be defended. In the form, usually what is mentioned is the end user's freedom of expression and information, the end user's need to protect the end user's personal data, as well as the right to the protection of their private life. Now, by attributing to each of these parties in the triadic relationship their rights and interests, the CJU and the ECHR have managed to essentially reinterpret questions of intermediary liability as questions of clashes between opposing fundamental rights. And then they have immediately found the solution to these clashes between fundamental rights, and that solution has been found in the so-called principle of a fair balance. So, for example, in 2008, in the seminal case of Permusique, the CJEU reminded member states that when transposing the directives, they have an obligation to strike a fair balance between all fundamental rights that are protected within the EU's legal order. And the ECHR has reached the same conclusion. Now, why have these two courts turned towards the principle of a fair balance as a solution in cases of intermediary liability? Each of these courts has given a different reason. They're very connected reasons, but they are subtly different. So the CJEU has indicated that in cases of intermediary liability, or at least in the cases that have arisen so far of intermediary liability, the fundamental rights that have been involved are not absolute, they're not inviolable, they don't deserve absolute protection. Instead, they are relative rights, that is to say, rights that can justifiably be restricted in order to protect countervailing rights and interests, and therefore a fair balance must be struck between them. The ECHR has taken a rather similar approach, although again, a slightly different approach. So what the ECHR has emphasized is that there is no abstract hierarchy between the rights that are involved in cases of intermediary liability. And instead, all of the relevant rights deserve equal respect. Since one of these rights cannot automatically trump the other rights, the only solution that remains is that of striking a fair balance. Now, of course, just because the ECHR and the CJEU declare that balancing is the name of the game and the solution to cases of intermediary liability doesn't mean that it is necessarily the correct approach. And indeed, many commentators have objected to the introduction of this principle of a fair balance to intermediary liability. So, for example, Tuomas Mili, who's an expert in human rights and intellectual property and constitutional law, has pointed out that if the analysis stops there, that is to say, where per musicae left it, so in the simple declaration that a fair balance is something that has to be struck, then balancing just remains an empty slogan that simply gives a fundamental rights gloss to the case law of the CJEU. Other commentators have argued also from a constitutional perspective against the principle of a fair balance. So, for example, in the US constitutional context, Aleinikov has worried that balancing approximates a black box and that it leads to arbitrary and unreflective outcomes, that it is empty as a methodology. Nevertheless, Stein and I reached the conclusion that we do not expect either the CJEU or the ECHR to backtrack from balancing, whatever arguments might be leveled against this methodology anytime soon. As a result, we decided to positively embrace the principle of a fair balance, attempt to sort of shine a light into the black box of balancing, and attempt to sort of construct a viable understanding of the concept of a fair balance in intermediary liability. Now, for this purpose, Stein's previous research into the concept of clashes between fundamental rights was particularly relevant. My co-author, Stein Smet, had recently finished his PhD on on the question of clashes between opposing human rights within the context of the Convention. And on this basis, we reached the conclusion that there are two possible conceptualizations, two possible interpretations of the concept of a fair balance. So a fair balance, the first of these interpretations is what we call ad hoc balancing. This refers essentially to a concrete weighing of competing interests in the particular circumstances of an individual case. Essentially, what judges do when they apply ad hoc balancing is they attempt to find in which direction the scales tip in the circumstances at hand, and then they rule accordingly. However, there is also a different conceptualization of fair balance, a different interpretation of fair balance, and that is fair balance as an equilibrium, fair balance as a search for a compromise solution. In this case, what judges are doing, what we are doing, is not so much looking for which way the scales, for the way in which the scales tip, but instead what we're attempting to do is level the scales so as to find a compromised solution, a solution that can preserve all the relevant rights and interests as much as possible. The advantage which equilibrium balancing, compromise balancing has over ad hoc balancing is that it can lead to results that are more principled and more abstract in nature, and this increases legal certainty as it provides greater guidance for future cases. We therefore embrace this concept of balancing as compromise. We suggested that in the area of intermediary liability, what is necessary is that all parties share the responsibility. None of them will be maximally, absolutely protected. Instead, all of them will have to make small sacrifices, so that instead of ending up in a sort of winner-takes-all scenario, all of the relevant parties' rights can survive coexisting alongside each other to some degree. Finally, we also suggest that it isn't the intermediary's responsibility to locate this compromise, to locate this equilibrium balancing, but instead that is a role that should fall to the states. And this is a solution that is dictated by a core principle of the law of fundamental rights and the law of human rights, according to which human rights and fundamental rights impose duties not on private parties, not on private entities, but instead on states. Therefore, it is the state's job to find a system which manages to preserve all relevant rights, to safeguard the rights, to achieve this balance, to achieve this equilibrium between all of the relevant rights that are at stake in cases of intermediary liability. But how would a state go about doing that? So what we suggest in the article is that the way forward has been indicated to some extent by the case law of the ECHR, the Court of Human Rights based in Strasbourg. Now, two cases stand out in this regard, and those are cases that have already been mentioned by previous presenters here today: Delphi versus Estonia, and MTE and Index versus Hungary. What's interesting about these cases is the different solutions that were reached by the court in each of them. So the case of Delphi versus Estonia concerned content that the court judged to amount to hate speech and incitement to violence. By contrast, in MTE and Index versus Hungary, the court reached the conclusion that the relevant content in that case did not amount to hate speech. Instead, it only amounted to offensive and vulgar content. In the first case, in Delphi versus Estonia, the court reached the conclusion that the imposition of a system of notice and takedown on intermediaries would be incapable of striking a fair balance. On the other hand, however, in MTE and Index versus Hungary, the court suggested that merely taking the content down would be capable of striking a fair balance. And there's a very indicative sentence from paragraph 159 of the Delphi decision that explains this. And what the court said in that decision was that if accompanied by effective measures that allow for rapid responses, then notice and takedown can function in many cases as an appropriate tool for the balancing of all of the rights that are at stake in cases of intermediary liability. This would indicate that a partial solution to the question of a fair balance in intermediary liability can be found exactly where it has been all along, that is to say, in systems of notice and takedown regimes, such as that can kind of be found in Article 14 of the E-Commerce Directive. But that will only be sufficient in many cases. In many other cases, presumably, a different solution has to be found, and indeed Delphi was one such case. What this indicated to us is that what is necessary for a fair balance to be struck in cases of intermediary liability is a calibration of the relevant rules depending on the type of content that is involved. So hate speech and incitement to violence might, for instance, be more sharply dealt with than merely offensive, merely vulgar content. And then the next question to ask, of course, becomes obvious: what lies between these two extremes? What should be the fate of other types of illegality? Now, in answering this question, we took a bit of inspiration from the evolving language. Excuse me. So we took a bit of inspiration from the evolving language that has been emerging on notice and takedown from the European Commission. So initially, the relevant documents handed down by the European Commission would make reference to notice and takedown. However, in recent years, this language has mutated towards the more abstract conceptualization of notice and action. And this indicated to us that perhaps there is a move away, in a way, from the horizontal approach towards a more calibrated approach, a more fairly balanced approach. So in the Commission's recommendation, indeed, from the 1st of March of this year on tackling illegal content online, the Commission also included a very indicative sentence. It said that due account should be taken of the relevant differences that might exist between different types of illegal content and the actions that might be taken to tackle them. On this basis, it occurred to us to attempt to sort of build a calibrated system of notice and action that assigns different actions to different types of illegal activity. Now, for this purpose, in sort of building this calibrated system, we sought to take inspiration from the entire world, essentially. What we saw is that there essentially is a global hotbed at the moment, a very rich continuum of notice and action possibilities. And perhaps this is in response to the shortcomings of notice and takedown that has been very heavily criticized over the years. Each of these approaches is designed to take a subtly different approach to unlawful activity online. And the most prominent of these solutions, we selected 7 of these solutions, the most prominent of these solutions that we sort of harvested from different jurisdictions among the world. These are these 7 solutions ranked as we saw it, from the most invasive to the least invasive, from the perspective of the intermediary and the end user. So we'd start with, for example, granting absolute immunity to the intermediary, so the intermediary is never liable. Then move on to a sort of system of notice and notice, where the intermediary, upon receiving notification that it is hosting illegal content, has an obligation to forward this notification to the person who actually posted the content. Then we also identified a system which we called notice and judicial takedown. This would require that there first be a court order before content can be taken down. Notice, wait, and takedown is a system which would indeed require that the intermediary take down the illegal content, but only after a short period for sort of judicious reflection, usually about a week. Another option is notice and suspension, where the intermediary has an obligation to take down the accounts of repeat infringers. Notice and stay down is an option. Under this, the intermediary would have an obligation, once it has been notified of illegal content, to make sure that that content is never reposted again online, does not reappear on its option. And then the strictest option that we identified was that of automatic takedown, which would essentially impose strict liability on the intermediary. The intermediary would have an obligation to take the content down even without waiting for notification. Now, to date, this diversification of approaches has primarily been geographic, with different countries investigating, experimenting with different options. However, what we argue in the article is that the time has come to start thinking about mixing and matching, so that we can develop best practices for different fields of law. The ultimate result would be a sort of calibrated notice and action regime that does attempt to achieve a fair balance. Before we can start, however, incorporating these various notice and action systems into our calibrated vertical system, we decided that it would first be necessary to, so to speak, separate the chaff from the grain. We began, therefore, by suggesting that some of these 7 options are entirely incapable of contributing to a fair balance, of contributing to a compromise approach, an equilibrium approach to intermediary liability. So the first of these worst practice scenarios, the first of these options that we rejected, is the option of absolute immunity. Now, absolute immunity obviously takes the side of the intermediary wholeheartedly. It does not attempt to offer any kind of compromise. Therefore, it should be rejected. There are some cases in which you might say that absolute immunity makes sense if we are to believe that intermediaries are really actually mere dumb pipe. However, as soon as the intermediary has actually received knowledge of the illegal content, this becomes something that is very difficult to maintain. Another option which we rejected is the option of notice and stay down. Notice and stay down is not so wholeheartedly anti-compromise as absolute immunity. Indeed, it does go some way towards achieving a compromise, in that it does at least require a notification. However, post-notification, it abandons all attempt at compromise. This is because identifying future repostings of notified illegal content would not be possible for the intermediary without human monitoring or without the installation of machine filtering. This would require complicated and costly systems for the intermediary, and it would also interfere with end users' rights to their freedom of expression and information and the protection of their personal data. And this is something that has been made clear by the CJU's analysis in the CBAM cases. We did consider that if there is one area in which we would introduce an exception to this rule, so that notice and stay down would be possible, then that would be for the area of child pornography. The same would be true, by the way, with regard to automatic takedown. Automatic takedown we also rejected, essentially for the same reasons that we rejected notice and stay down. It does not allow for a viable compromise, and indeed does so even less, given that even this nod towards compromise in the form of a notification does not exist. However, in the cases of child pornography, we do suggest that potentially both notice and takedown and automatic takedown might be appropriate. This is due to the severity of the injury that is inflicted on the injured party that necessarily, in a way, tips the scales, making a compromised solution impossible. So that left us with 4 options that could form part of our calibrated notice and action system. We suggested in our article, and there's a lot more detail, of course, to be found over there, that notice and notice systems should be reserved to cases of infringement of intellectual property rights. Excuse me. In this, we took inspiration from the example of Canada, that has deployed a system of notice and notice to great effect in cases of copyright infringement. We then also suggested that notice, wait, and takedown might be an appropriate system in the area of defamation law. Notice, wait, and takedown is a system that has been pioneered, as far as we could tell, in Japan. In Japan, it applies a more horizontal approach. However, we took note that it is quite similar to the system that has been introduced in the UK under Section 5 of the Defamation Act of 2013 and the accompanying regulations, and as a result we suggested that it might be appropriate for the area of defamation where figuring out the illegality of the content might be difficult for the intermediary, in the same way as it would in the cases of intellectual property rights infringements, but the injury inflicted on the injured party would arguably be a bit more urgent. Thirdly, we reserved notice and takedown, complemented by a system of notice and suspension for the area of hate speech. In this, we were inspired by the Code of Conduct that has been negotiated by the European Commission with a number of large platforms, such as Google and Facebook and so forth. We did take note that this would be contrary to the findings of the ECHR in Delphi, which required automatic takedown in cases of hate speech. However, we couldn't find a way to reconcile this outcome with the law with the case law of the CJU on automatic takedown and filtering, and therefore we landed on notice and takedown and notice and suspension as the next best option. And finally, we also left a sort of all-purpose compromise, a fourth all-purpose compromise in the form of notice and judicial takedown. That is, of course, the traditional system, the system that bypasses these newfangled self-regulatory intra-industry solution and takes the more traditional court-focused model. Of course, we understand that this is a system that would require costs and impracticalities and impose a burden on the court system. However, we would note that these are drawbacks that have always applied in the offline world, and different solutions have been found there to counteract them, such as, for example, summary judgments, temporary injunctions, the creation of authorities, and so forth. Solutions could be found. In any case, notice and judicial takedown is only suggested as sort of like a backup option that applies in all different cases. The ultimate result, we hope, we propose, we're not entirely convinced, but we're putting the idea out there anyway, is potentially a compromise in the area, a compromise approach, an equilibrium approach in the area of intermediary liability. A calibrated notice and action regime that actually does attempt to achieve a fair balance, if you will, a system of notice and fair balance. If nothing else, then at least what we hope to do with writing this article is opening the discussion on the advantages of a vertical as opposed to a horizontal system, as opposed to the horizontal approach of the e-commerce directive. And doing this would represent a first step in shifting the intermediary liability debate in the right direction, towards the direction of fair balance. I'd be very happy to hear any feedback you might have on this. Thank you very much.